Welcome back to Good Law, Bad Law. It is sometimes called the billion-dollar baby of one of the largest chemical companies in the world, Monsanto, now part of Bayer. And we're talking about Roundup, the ubiquitous weed killer, probably in everybody's garden shed or on a shelf in your garage. You have at one point had Roundup. And it is also the subject of a very important bellwether trial taking place in federal court in San Francisco. And to help us understand the particularly complex and really important scientific evidence aspects of this case and the broader implications, I welcome my guest, Edward Cheng. He is a professor of law at Vanderbilt Law School. Ed, thank you so much for being on the program.
Well, thanks a lot for having me. I'm excited to be here.
This is really, in many ways, an exciting case, no matter where you come down on the question. So many questions of scientific evidence that are crucial to how a federal jury just the other day found in a unanimous verdict in this federal court a case that Roundup indeed is responsible for causing the plaintiff's cancer. He has non-Hodgkin's lymphoma. And we're going to explore today how the scientific evidence is crucial and what are the broader implications and what are the challenges in having a jury of lay people decide these very, very complex scientific questions. Uh, Ed, I wonder if you could give us a little background on yourself, because this is an area that you've really concentrated on in your research and in your teaching, the issues of evidence and science. Give us a little bit of the background on yourself as we get started.
Yeah, so I've spent most of my career thinking about this intersection between law and science, how experts interact with the courtroom, and how lay decision makers can best make choices about things that they don't know a whole lot about, or that involve a lot of specialized knowledge, involve people who spent many, many years of training developing an expertise in an area. I also have a background in statistics. I think in many ways, one of the reasons why I went back to graduate school to think about statistical issues was that I was finding that a lot of these cases involved statisticians and statistical studies, and I wanted to have a sense of what was going on behind the scenes so that I could have a better idea of what we might teach juries and judges who have to make these kinds of decisions.
Well, and the science of epidemiology too, which is really the science, some say a social science on the cause of disease, which also involves very statistics-based material and is so important in all kinds of science-based trials, particularly those involving whether a product or a chemical could be the cause of disease. And so we'll talk about that as well. And you're being very humble to leave out some details of your background, Ed. You're a graduate of Harvard Law School. You got a Ph.D. in statistics from my alma mater, Columbia, New York. And of course, your work, since you've been at Vanderbilt, you've published in some of the more prestigious law journals in the country, including the Stanford Law Review and the Yale Law Journal, the Yale Law Journal. So you have, and I should also say, since this is a podcast, that you have your own podcast. Why don't you just include that and give that a mention so we know about that too?
Yeah, so I am the host of a podcast called Excited Utterance. Those of you who remember your evidence rules will remember that the excited utterance exception is an exception to the hearsay rule. And the idea behind that podcast is really, it was designed to be a forum for legal academics to share their articles with each other. I thought it was a more efficient forum for doing what is effectively a faculty workshop where you can share your scholarship with other evidence academics in the country. turns out that the audience for this podcast has become much wider than I had ever hoped. And I now sometimes get comments or emails from people who are in practice. I get emails from students. And in fact, I've had one very strange coincidence where there was a student who was interested in going to law school and as an undergrad listened to that podcast and then discovered that I was his torts professor for his first year. So it's been a very rewarding experience. It also has given me the opportunity to meet a lot of young, promising new professors in the legal academy.
Well, that's great, and that's a big part of the underlying idea behind good law, bad law too, which is not only that lawyers and law professors and law students are interested in law, but so many people having nothing professionally to do with the law are interested in. And this is really a great example of the topic we're talking about today, because so many things that people deal with in their daily lives end up becoming the subject of important court cases. And we're going to be talking about Roundup today, but a lot of the issues we'll be discussing having to do with the science that is so central to the way this trial will proceed and the way issues will get decided are issues very similar to those that have come up in litigation involving tobacco, in cases now that are pending all across the country involving opioids. Talcum powder has been the subject of cases of a similar nature all across the country. So issues of science and what science can come in and what science can be used to prove the link between exposure to a chemical or a product and a disease. This is something that juries and judges wrestle with all the time in some very important ways. So
I should point out that
yeah.
It's not just juries and judges. Obviously, as a legal podcast and as lawyers, we focus on the courts and the various institutions of the courts. But in many ways, I think the questions that we're asking here are ones that every citizen should ask themselves, which is when you decide whether or not you want to go to the hardware store and buy a bottle of Roundup and you want to spray it on weeds, what kinds of precautions you want to take, what concerns you might have about that product. That's, again, a lay person trying to accumulate knowledge. It's not going to be fed to you as in a courtroom, but you're trying to accumulate knowledge as a lay person. You're trying to make an educated decision about something that you don't really have a lot of training in deciding.
Well, I totally agree with you on that. And, lay people, the way the media writes about these kinds of stories and, what evidence, we think of evidence as something that is important in the courtroom, but you're right. Evidence is something important to all kinds of decisions we make as individuals, what kinds of support a reporter uses in writing a story about something like this. So it is very important. To set the scene for us here in understanding this case, I think it might also be, and I'll ask you to do that in a moment, but I think it's important also to distinguish between what we commonly understand about the way medications, prescription drugs, gain acceptance and gain really admission into the marketplace versus non-prescription medications, because I think that perhaps people don't really realize that there is a process for vetting the scientific claims of, say, a drug company wanting to introduce a new heart medicine or a new diabetes pill, for instance, and a chemical like Round or a product like Roundup that has a chemical base to it. So maybe you could set the issues for us here. What is the issue with Roundup, and what is this case about? And then we'll get into what the science questions are that this case is raising and wrestling with today?
So the key issue, I think, in these Roundup cases, aside from, say, Monsanto's behavior, whether or not they knew that Roundup could cause certain diseases, I think the key issue and key scientific issue is whether or not glyphosate can cause the non-Hodgkin lymphoma that is involved in the case. And that question is a very difficult one because, unlike, as you were pointing out, in drug cases, first of all, before your drug is approved, you usually have a whole battery of tests, and you have random clinical trials where, in these cases, you have a control set where you did not expose that set to the particular drug, and then you have an experimental set, and you test the safety of the drug that way. Now, even in drug cases, because these random clinical trials have pretty small sample sizes, you can run into problems where you're not doing an experiment. You have to reason from the general population once certain members are exposed to them. But let me flip back to the Roundup case. So here you don't have any kind of experiment. You obviously can't take out a whole bunch of people and spray them with Roundup repeatedly over the course of several years and then see what happens to them versus a control group. What you have to do is you have to infer whether or not Roundup can cause whatever disease it happens to be based on observation. And the problem with observation is that there can be a lot of different confounders. So one problem with people who use Roundup on a consistent basis occupationally is that they're also exposed to other herbicides or insecticides. These are often groundskeepers or people who work in agriculture. There are claims that people who also work in these industrial agricultural contexts are exposed to known carcinogens like diesel fuel fumes or high amounts of UV radiation because they're out in the fields. And then you have something of a puzzle because the question becomes, was the cancer caused by the exposure to the glyphosate? Was it exposed to the exposure to other kinds of chemicals that are involved in the in that environment? And then it becomes a statistical matter of trying to control for those statistically. But, statistical studies can only do so much, and so then there's a process of trying to get through the uncertainty or trying to look at it in different ways so that you can get rid of some of that uncertainty.
Well, so let's explain some of that a little bit more. So first of all, glyphosate is the active chemical ingredient in Roundup. Is that right?
Yes, that's right. There's so some of these herbicides with glyphosate also have a surfactant which helps the plant absorb the Roundup and makes the Roundup more effective. And at least reading some of the literature from various governmental agencies, those surfactants are sometimes thought to be even worse than the Roundup. And so you immediately have a possible confounder there as well. So it's not clear whether it's glyphosate or whether glyphosate plus the surfactant or whether it's just the surfactant itself.
So when you say a confounder, that means there could be other causes of a disease that we're not considering because we're only focusing on, in this case, the glyphosate.
Yes, and often these confounders, these other causes, are correlated, meaning that they appear together with the exposure to the Roundup. So, as I was suggesting earlier, if where Roundup tends to be used or where people tend to be exposed to large amounts of this are also contexts in which they are exposed to some, say, hypothetically, some chemical X, then we have trouble separating whether or not the disease was caused by chemical X or whether the disease was caused by the Roundup. And again, because you can't conduct a true experiment, it is very hard to separate those things.
Well, and so let me follow up on that, because I think that's also a very core idea here. Again, to compare to the system that we have in place, not only in the scientific community, but in our regulatory system. We have an agency called the Food and Drug Administration, the FDA, which regulates pharmaceuticals and other products as well, like cosmetics and things like that. But when a drug company wants to introduce a new, again, so let's say a new diabetes pill, they have to put it through different kinds of tests. And you alluded to the human testing, which is what I think you called experimental testing. But there also are animal studies that can be done, and I think are required to be done as part of the process of getting approval for a new drug. And obviously, there's a big difference between doing research, experimental research for a new drug on mice, let's say, compared to doing that type of research on a human being.
So that's absolutely true. I think actually, though, that there are, in this respect, I think there are actually more similarities from the drug context to this chemical context than might seem at first glance. Yes, in the drug context, you have this testing being done up front, and in the chemical context, you may have none of this upfront testing, and it depends on the context. But you certainly can do those animal studies, and I believe some of these studies have been done on animals with the glyphosate. So you can have the toxicology studies there. One difference is that you do have the human random clinical trials in the pharmaceutical context. That's the kind of natural or the true experimental process, where you have a control and an experimental, and you give one a placebo and you give the other the actual drug.
Right.
And you don't have that in the chemical context. But the problem is that in terms of the statistical power, the ability to detect effects, those random clinical trials are limited because they can only be so large. Even if you have a sample size of 2,000 or 3,000, they are already in the millions and millions of dollars. So what usually a lot of the big pharmaceutical cases like Vioxx, those cases are also very much ones that are that rely on epidemiology, rely on observing things, using proper techniques to make inferences about whether or not the drug caused the disease. So if you think about probably the most famous case in this area, the Daubert case, which involved a drug called Bendectin, the concern there was, so there was a drug that was given to pregnant women who suffered severe morning sickness, and that drug was suspected of causing birth defects. Well, the problem there was the women who were given this drug were women who had this particular condition, and then you have, potential confounder that epidemiologists had to worry about. Do women with this condition have an elevated risk of birth defects? Do these women also take other drugs that are associated with a higher rate of birth defects? Those are the kinds of concerns that, again, you have in the Roundup case as well. So in any of these mass torts, I think you always have these issues.
But a well-designed epidemiology study certainly would at least consider those potential confounders, like you were saying in the Bendectin cases. Do women who have morning sickness have other, predispositions that you have to take into account? But why is it? And I've wondered this for a long time, and I've handled cases involving medical and scientific evidence, including cases where we are trying to make a link between a chemical exposure and a type of cancer. Um, isn't that a crucial difference, that there is upfront testing that's done for a new pharmaceutical, even though it may have its limitations, and even though it may uh, happen that once that drug is approved and gets wide, is used widely in the population, there may be indicators that become apparent that there is a problem that wasn't picked up in that earlier testing. But at least there's some upfront testing done, and yet when it comes to chemicals in our country, in our system, there's no testing required. So it does almost seem like it's all backwards looking science when it comes to a chemical like glyphosate in a hugely widely used product like Roundup. It's only when there's a problem that that it seems we start to look at what could be the health implications of exposure to this. Why can't the same approach be taken to something like Roundup and other chemicals? That is, that you would do at least some upfront testing. Because you could certainly do animal testing without putting human beings in a situation as you described, where you said, "Let me spray you with this Roundup and see what happens." That obviously is problematic for ethical reasons, but the same concerns don't apply when it comes to animal testing. Yet we don't require animal testing before a product like Roundup gets into the market.
Yeah, so I'm not sure. I don't know whether under the regulatory regimes, I think there are different regulatory regimes depending on the industry that you're in. I don't know whether or not there are required toxicology tests that have to be done on things like herbicides, or or fungicides or anything like that. Um, it's an interesting question that you raise, that company comes up with a new chemical, thinks that it's the latest and greatest, and then we don't know whether or not that particular substance is going to be toxic at some point. And it seems that there are a lot of these instances where something that seemed to be a great new chemical with with some great properties then turns out to also have toxic properties and causes a huge litigation on the back end. In some ways, I think it's the difference between tort and regulation. If the whole idea is that the tort system is supposed to create enough deterrence so that companies do not come up with toxic chemicals and fail to test them because they would suffer on the back end, versus having regulators step in at the front end and make sure that these things are safe. I think there are reasons for why you would be particularly careful about things that people are going to ingest, and I think that may be why we have that in terms of the FDA. But yeah, I think it's a classic dilemma whether or not really ex post litigation is going to induce proper behavior.
Well, yeah, and of course, there's a huge cost involved, and drug companies, when they are justifying drug prices, will often point to the research and development costs that go into bringing a new drug to market, which for the most part, uh, in terms of a regulatory scheme, chemical companies don't face the same costs. There's a Federal Trade Commission. There are rules about false claims in advertising products, but there's no. I don't think there really is a front end requirement. There is a tort risk. You're right, and I think that's why cases like this Roundup case in California become very important, because it is in the courtroom often where uh, companies are held to account for putting dangerous products into the stream of commerce, into the grocery store, hardware store shelves where people will use them and potentially be harmed by them. So I think that then does bring us to the courtroom, and we've talked about a couple of different types of scientific evidence that could be used to show what we lawyers call causation. That in this case, that glyphosate is the cause or can cause cancer. This gentleman had non-Hodgkin's lymphoma. We've talked about animal research, we've talked about human studies, and we've talked a little bit about epidemiology, which is more of a looking back at things that have already happened and trying to understand whether we can tease out of the evidence a cause. So maybe you could talk a little bit about the challenges that that this plaintiff, this gentleman in California, faces in trying to show that glyphosate is the cause. And I think maybe you also have to talk about two different kinds of causation here, because we know there's general causation and then there is specific causation. Maybe you can speak to that as well a little bit.
Right. So there, so you have to prove that glyphosate caused your particular case of cancer. And as you pointed out, there's this general versus specific causation breakdown. The general causation question is the broad one, and the one that epidemiology and these other toxicology and these other scientific disciplines are best able to address. The general causation question is, can, as a general matter, glyphosate cause non-Hodgkin lymphoma? Now, the difficulty with proving the general causation piece is what kind of expertise should the legal system accept in trying to determine this issue. One way to do it is to allow certain experts to come and talk on a clinical level. So you have a doctor who sees patients all the time, and these doctors have patients come and ask them, well, should I be worried about, I spray glyphosate all the time in my job, should I be worried about it? And the doctor has to give a judgment on whether or not this is potentially a danger. And in fact, at least in the state court case that was decided in October, one of the prominent plaintiff's experts was a clinician, and the person, said so and said, well, I looked at some of the studies and I had to make a clinical judgment. Then you have the toxicologist, but that also requires a certain kind of inference. So let me back up for a minute. If you talk about that clinician, the problem with the clinician is, well, there's no necessary scientific study backing that clinical judgment. You might worry that a particular doctor has seen a bunch of cases where people have been exposed to glyphosate and came down with this cancer, but you don't know whether there are selection effects associated with the doctor seeing this. You don't know whether the doctor just happened to get unlucky. If you have 100,000 doctors in a given area, one of them may see a lot of cases in this way, but that may be just random chance. So there are issues.
Yeah, it could be pure coincidence. You don't know.
Yes, that's right.
On the other hand, when I've seen a clinician used as an expert to try to prove causation, usually the rationale for why a clinician would be somebody who could make that kind of judgment, who could give that kind of an opinion that a certain thing was the cause of a particular disease, would be based on the idea that is really basic to medicine, which is the differential diagnosis, which is a concept that doctors use all the time. They have a patient who comes in, has certain signs or symptoms, and then they have to decide from the several things that could explain those symptoms, which is the one that I can rule in and which is the one that I can rule out. I might do testing. I might look at the scientific literature to see what that might say. then that's a process that doctors do all the time, every day. So, but that is very different from, say, what an epidemiologist does or what a toxicologist does. Is the law less inclined, or are courts applying the law of what type of scientific evidence a jury may hear generally less favorable toward that type of differential diagnosis opinion?
If you look out in the literature, it's really interesting because there's no hard and fast rule. I think it would be fair to say that there's no hard and fast rule, and in terms of what particular evidence is going to be acceptable. And I think the reason why there is no hard and fast rule is that courts tend to be pretty practical about these questions. So there are some cases where you're never going to really get the statistical epidemiological study. And that's just based on the facts of the case. There's it's a relatively famous case called Zukowitz, where the plaintiff was prescribed a pretty massive overdose of steroids, and that part was admitted, that she received a very large amount which she should not have received from the pharmacy. But then she develops a rare disease afterwards, and then the question is, well, did the overdose cause the disease? And in those kinds of cases, you're not going to be able to have a statistical study because no one ever receives, a quadrupling of the maximum dosage of a drug. And in those cases, at least in that particular case, the court did not require epidemiology. But if you look at, say, the Daubert case, we go back to the Daubert case in Bendectin again, I think there, where the science had matured to the point where there were a large number of epidemiological studies, the courts basically said, we'll go with the epidemiology, or the epidemiologists can testify, and we're going to exclude the clinicians and the toxicologists. So a lot of that, in many ways, it just depends on what kind of evidence you have out there. It's a very odd thing from a theoretical perspective for the courts to be doing that, because if you look at the Daubert standard, it doesn't say, well, admit the best stuff that you have, or let's look at how mature the scientific studies have become in this area and then admit those. Daubert's supposed to be an absolute standard. It's supposed to be, if it's the result of reliable methods, then it should be admissible. But I think in the rough and tumble of the real world, I think courts have been pretty practical about the kinds of evidence that they'll allow in these cases.
Yeah, and you're mentioning now that you had earlier told us about the Daubert case, and now you're mentioning the Daubert standard. Explain that, because there's a federal standard, Daubert, and then there's a standard that's used, somewhat similar standard, in certain state court systems called Fry. So what is that standard, and how does that affect what type of evidence, scientific evidence, a jury will hear?
Doctrinally, Daubert is a multi-factor test that was imposed by the Supreme Court in 1993. And the multi-factor test was, you go and take a look at the expert and see whether or not the theories were, one, falsifiable, meaning with a view towards science as testing hypotheses that you can disprove, whether there were studies that were peer-reviewed, relying on the reliability that comes from publication and having your peers check your work. There were concerns about error rates and standards, depending on the particular technique that you're talking about, whether or not you got information about how often the technique is wrong. And then finally, whether the science or the method was generally accepted in the relevant scientific community.
Right.
So that's the Daubert standard. The Fry standard, which is older, it comes out of a 1920s case, really is talking about general acceptance. And various jurisdictions have different spins on these. I think the easiest way, or the simple way of describing it, is that Daubert is a standard in federal court, as you mentioned. The majority of states have adopted this Daubert standard. There are some significant jurisdictions that have remained with the Frye standard, in particular California. So the state court case in this glyphosate saga was done under a Frye standard. California has modified Frye in these weird ways. So it's kind of Frye-like and Daubert-like in different aspects. And then there's a considerable literature that asks whether it really makes any difference what the standard is that's being imposed. And the reason why there's doubt about whether or not it really makes that much of a difference is that, for the most part, these factors don't always apply to the particular expertise that is involved in the case. And if you think about what judges are going to have to do, they're basically taking what I term a hard look. It's almost, to borrow something from the regulatory context, judges are taking a hard look at the expert and seeing whether or not the expert is cognizant of limitations, whether the expert is overselling, whether the expert understands where the expert might have gone wrong or what the possible alternative explanations might be. And then the judge simply decides admissibility based on that kind of intellectual rigor test. And if that's what's going on, then all of this is pretty much the same. I think that the key, though, is that all of these regimes assume that there is gatekeeping, that the judge really does need to take a first cut and screen out experts that are unreliable or potentially misleading to the jury, as opposed to a more laissez-faire approach, which would be to allow all these experts to testify and leave it up to cross-examination to ferret out all the problems that the expert's testimony presents.
Right, and the judge has a gatekeeper role when it comes to all evidence, right? I mean, not just scientific evidence. There's all kinds of situations we know. The name of your podcast, Excited Utterance, is an example of a kind of evidence that, in a motion before the start of trial, one side might say to the judge, "Hey, keep out this evidence. It's hearsay," and then the other side will say, "No, there's an exception. It's an excited utterance that was made, in the face of a trauma, or in some other way where we think that that evidence has more credibility." And then the judge has to rule: is that evidence going to come in or not? Is the jury going to hear it? So both of these tests that you've talked about, Daubert and Frye, I believe, involved an offer of an expert testifying on the basis of polygraph testing, and it was ruled that that was what we now call junk science. And the judge said, that's not going to come in. I'm not going to let the jury hear that evidence. It's unreliable and therefore misleading. So there's all kinds of ways, but with scientific evidence, it's particularly important to manage the evidence that the jury is going to hear, because of the great potential for misleading the jury regarding, you have an expert, you call someone an expert witness on a scientific question, and a jury's going to tend to think that that expert is offering evidence that can, be relied on. And if that testimony is based on unreliable science, then it'd be appropriate to keep it out. So what can you apply that then to perhaps what the particular challenges have been in this Roundup case? Because as we are recording this episode, Ed, the plaintiff in that case did get past the first phase with scientific evidence that the court ultimately did allow the jury to hear, and the jury found that glyphosate does cause cancer. So I don't think they found that it causes this person's cancer, which raises other questions about how much glyphosate he was exposed to, what was the dose, in other words, of the exposure in order to show that this chemical caused this particular person's particular cancer. But they've gotten past the first phase, which is pretty extraordinary when you consider there are thousands of other Roundup cases waiting in courts across the country. What were the particular challenges in terms of evidence or categories of evidence? Can you help us understand that part of this a little bit?
So the challenges, so first of all, the challenges are twofold. The judge, in doing the Daubert analysis or the Fry analysis, has to decide whether or not the experts that are presented are sufficiently reliable to go to the jury. And as we talked about early in the episode, the judge, and I often joke with judges that one of the reasons why people go to law school is that they don't like science and don't like math. And so what you end up with is someone who doesn't like science or math having to make decisions about whether or not the science and math are sufficiently reliable. And so that immediately presents an issue. And then even if you pass the judge, now you have a jury. And I think judges have something of a competitive advantage versus the jury in this regard because they're repeat players. They can go to various conferences or judicial programs to help teach them or make them more comfortable with this material. But then now you have a jury that is trying to make really the ultimate determination, and again, doesn't necessarily have the background necessarily to make this the decision. And at the same time, I think what you have are what's often described as the classic battle of the experts. You have two experts, or you have two sides worth of experts.
Yeah.
And they are almost always highly qualified experts in both the federal case and the California case with Roundup, highly qualified experts on both sides, and they disagree with each other. And Learned Hand had a law review article over 100 years ago, and just to show you, how wise he was.
Famous judge from New York, Learned Hand, yes.
Yes, and Learned Hand asked, well, how is the fact finder supposed to decide between these two experts when the reason why you have the experts in the first place is that the fact finder doesn't know anything about the topic? So you have basically given the jury and the judge the most difficult scientific questions possible, the ones where you have experts on both sides disagreeing with each other, and you are asking them, the lay persons in the case, you're asking them to make the decision. And it's interesting if you look into the philosophical literature, this problem is very, very old. It's thousands of years old, where Greek philosophers asked, how are you supposed to determine expertise if you're not the expert?
Well, that is a very deep question. And it does run through our legal system, right? Not just in a case like the one involving Roundup, but you could say that juries decide very difficult questions all the time. It is a jury that will decide whether an individual goes to his death in a capital punishment case. So what is it about? There are a lot of things that juries decide that they don't necessarily individually have expertise in. Does cross-examination? Cross-examination, I think, does serve a purpose here. Right? You can say, well, you have a battle of experts, but you would imagine that, say, the plaintiff's epidemiologist is also going to try to point out flaws in the defendant's epidemiologist and vice versa. So they're not only going to put forward their own case, but they're also going to be looking across at each other. And you know, if juries can decide complex issues in other situations, what is it about scientific evidence that we in the law give? We give a different kind of deference to, are critical in the way we examine it, so much more so than when it comes to other types of evidence.
So it's interesting. So from my perspective, I think that the problem in these expert cases is different from the usual hard cases or hard issues that juries have to decide. I think in many of the usual cases that juries have to decide issues or facts, they're hard questions, no doubt, but the jury is competent to make the determination. So jurors have to decide credibility. And, for the most part, there doesn't seem to be a significant expertise on determinations of credibility. Juries have to decide whether facts or a narrative fits together. Again, something that everyone can render a decision on. Whereas when you're talking about a scientific case, the problem is that the people who are the experts, these people have been extensively trained. They've spent years in school doing this kind of work and learning how all of it comes together, and then they have years and years of experience putting it together. And I think that puts them on a slightly different plane versus the jury. And I think this is the reason why oftentimes, you go see an expert when you have a problem that is specialized. You would go and hire a plumber to fix something that is wrong with your house that you don't really understand how things are going, or you go to a doctor, right? And I think that's the most common case. Or you go to a lawyer to help you present your case because you don't have the background to do it. So I think these cases present a particularly hard case for the jury to decide. Now, I think what is going on in these cases, though, is, or the way that the legal system handles it, is that really we're still asking the jury to do the same process that they handle, in which they handle regular witnesses. They're trying to apply the same tools to the expert witnesses. And I think it's particularly hard, not only because of the competency issue, but also the nature of the experts themselves.
Mm-hmm.
Normally, when you have witnesses in a case, so a garden variety car accident, those witnesses are a limited population, and those witnesses are not paid. So paying a witness in a regular case is tampering with the evidence and is a criminal offense. What you have in an accident case is you get the witnesses you can, you bring them in. They're often neutral. Sometimes they're not, but you can show how people are related to each other, and you engage in cross-examination to test them, and the jury can make its assessment. With experts, the issue here is that the parties hire the experts, and much is often made about how experts are hired, and so they become hired guns. I'm actually less concerned about the payment aspect. I think a lot of these experts have considerable professional reputations and are not going to change their mind purely on the basis of who's paying the bills. Although psychologists have shown us that it does make a difference. But the key problem is not the payment, I think, but that the fact that the experts are selected. Mm-hmm. So to the extent that the attorneys can go out into the broader population and find the few experts that best represent the position that the attorney wants, you have a cherry picking that is going on that makes it very difficult for the jury to give any context to the people that the jury is hearing from. And I think that is, that so overlaid, over on top of the problem of competence and expertise is this problem that you have a very carefully curated set of witnesses that the jury is hearing from.
Well, let me push back on that a little bit, Ed, because because I think you're raising a number of different points. And you mentioned a simple car accident case, and sure, there you're dealing with eyewitnesses. For example, you can imagine two eyewitnesses have different recollection of what they saw or saw things differently, and that's one thing. But you could have a more complex car accident case that involves how a feature of a car was designed or manufactured, and those would require a very different level of expert. And you could get into some of the same questions we're talking about here. I've always found in my experience, because all of my cases involved medicine and science, there are always experts on both sides. And always those experts have more training and more expertise than the members of the jury that have to decide. I have a case going to trial in a few weeks. It's a urology case. We have a urologist. The defendant has a urology expert. I'm pretty sure none of the jurors have ever taken even a single course in urology, let alone all the training that you have to go through to become a urologist and the years of practice in that field. So I wonder if there's something about the nature of scientific causation itself that makes the challenge of deciding what type of science and what type of scientific expert a jury will hear from in an important case like this so distinctive. Because when it comes to human health and causation, we're really getting into such a different world of science. I had a case involving livestock that was affected by a chemical exposure, and there was property loss to our client, a big company, agricultural company. And there's just a world of difference when you're talking about did a particular chemical cause the death of an animal, say, and the scientific causation issues that come up improving human causation. So, I wonder if the issue is really the nature of scientific causation itself, as much as it might be about, whether an expert's paid, because both experts on both sides of a case are going to get paid for their time, for sure. What do you think about that?
It's very interesting to hear you make this distinction. To my mind, I think all of these experts pose really very similar issues. Mm-hmm. So whether or not you're talking about the livestock being exposed, or the urology case, or forensics case, or the glyphosate case, I think the fact finders in these cases labor under the same constraints or the same burdens, that you have a fact finder that doesn't know a whole lot about the science that is involved. And sometimes the science is more intuitive than others, but in a sufficiently complex case, these are complicated matters. And you have experts, and again, as I said before, I'm less concerned about them being paid, but mm-hmm. the experts are curated, unlike ordinary eyewitnesses, where basically you're stuck with the ones that were there at the time that the event occurred.
Right.
And I think those aspects make what the jury has to do very difficult. Now, you mentioned urology, and I don't know the specifics of the case that you were talking about, but one interesting context where we do something a little different, and this is the topic of a new project that I'm working on, is in medical malpractice, we don't ask the jury the foundational question. We don't ask the jury typically whether or not what the doctor did was advisable. We don't ask the jury to determine whether the procedure that the doctor did was reasonable. We instead use medical custom, which has a bit more of a deferential feel to it. Mm-hmm. And when you do that, I think then what that places that subtle shift to the custom standard changes the competency of the jury to determine it. Because if what you now ask the jury to do is to decide what does the medical profession do in this context.
Right. We call that the standard of care. Right.
Right. The medical standard of care. Right.
Correct. Yes.
Then what's going on there is a question that I think jurors are competent to decide. Now, it doesn't mean that it's an easy question. That's a question, you'll still have experts on both sides arguing one way or the other, but that's, I think, quite different from asking the jury, well, should you have cut here or cut there? And I think that my new project sort of tries to see whether or not that may be a way out of the puzzle that we've put ourselves in.
Well, how would that apply then to something like the RoundUp case? Because we don't have it wouldn't be a standard of care question in that type of case, the way it would be in a medical malpractice case, where you would have one expert saying, here's what the standard of care is in this situation, meaning here's what it is reasonable to do or not do in this situation. The other side's expert's going to say, wait a second, that's not the standard of care. This over here is the standard. So you have an argument about what is the standard of care. You have an argument about whether the standard of care was followed. In other words, whether the physician was reasonable. But in these science cases, you can't have somebody just get on the witness stand and say, I think A caused B. I think glyphosate caused non-Hodgkin's lymphoma. As we've talked about, they have to first go through a very rigorous gatekeeping review by the court, in which their qualifications are examined, their methodology is looked at, the evidence they relied on is looked at. Are there any scientific peer-reviewed articles that support the approach that expert took? And all that has to be reviewed and cleared by the judge before a jury's going to hear it. And then when that witness goes before the judge, they're going to have to lay all that out in front of the jury. Say, not only is this my opinion, but these are all the things that I did. These are all the studies I reviewed. This is the testing that I did, if it's an epidemiologist, to reach the opinions that I have. So why, it almost feels in a way like a scientific witness has to do a lot more to justify whatever opinions they're going to come into court with than many other categories of witnesses you could compare them to.
If you wanted to draw the analogy from the standard of care in a medical malpractice case, you might say, or you might ask the question in one of these causation cases, what is the consensus, or what the majority of the scientific community thinks is the answer in this case? And that's very similar, I think, to saying this person presents with this disease. What is reasonable within the medical community to do in this case? And in the causation case, the question would be, well, what do epidemiologists writ large think about whether or not glyphosate can cause non-Hodgkin's lymphoma? Now, so that's the analogy. But now let me back away from that for a minute, because the reason why the RoundUp case is so interesting and so difficult is that even on that score, I don't think, even if you adopt this analogy from the custom of medical malpractice, you still don't solve your problem, because the relevant governmental agencies in the RoundUp case don't agree with each other. There is there is a committee of the World Health Organization that in 2016 made a lot of waves by saying that glyphosate was a probable human carcinogen. But first of all, even there, so that they are the most pro-plaintiff position, even there they say, well, there is limited scientific evidence suggesting that there's a link, but we haven't been, the evidence hasn't accounted for all the possible confounders or all the possible problems that are in these studies. So,
you're
it's a tentative.
You're talking about IARC?
Yes, this is the IARC, IARC.
Yeah,
And,
that's the International Agency for Research on Cancer, IARC. Yeah.
And so they're saying, well, you should be careful, and we should think about this, and we need more research, and scientists always want to do more research.
Right.
And at the same time, you have a number of other governmental organizations, the EPA, the European, some relevant agency of the European Union, Australia. All of them have concluded that there is no link, or there is insufficient evidence at this time to suggest that there is a link.
Well, see, well, go ahead, finish your point. No.
Go. Okay. So you have, I think you have a disagreement among the various agencies, and then as I think is the usual concern, some of these agencies may be captured by various interests, and so they may have a certain bias, and so that, of course, is something that juries would have to consider. So even if you moved it to you changed the question and you made it a question that at least to my mind, I think the jury is more epistemically competent to decide, I don't think you can really decide that case very easily in the case of Roundup.
Well, see, that brings me back to something that I started with, and I have to admit, and I'll disclose that I represent individuals and families. I'm more likely to be the lawyer representing the person suing Monsanto for Roundup, and would never be the lawyer representing the company in these cases. So that is my bias, but it's also my experience and my perspective on this. But I come back to what we started with, which is unlike, say, what the FDA does in requiring pharmaceuticals to upfront demonstrate the safety of a particular new drug that the company wants to introduce. We don't have anywhere in our system where these things are studied upfront. There is no. It's interesting that IARC. It's only recently that IARC has come out and said anything. And for IARC to come out and say it's a probable human carcinogen is already saying a lot, because there isn't a real long list of chemicals that get that designation from IARC. It's a very short list, in fact. Other agencies that are now and only now starting to look at this, I think really because they are prompted to do so because of the litigation that has started. There have been concerns about glyphosate and Roundup for a long time, but now that these cases are starting to reach trial, now we're starting to see some interest among these agencies. But until that time, who would it be that would do this research, right? I mean, individuals don't have the money to fund an epidemiology study. The government isn't on its own taking a look at the thousands of chemicals that are out there in the market and saying, let's devote millions or billions of dollars to research to try to see which ones are safe or not. That's not happening. The companies aren't on their own doing this, other than what they may be doing behind the scenes, which research only, frankly, comes out during litigation like the Roundup. So in order to prove scientific causation, you're right, there is the challenge of finding enough evidence, but you're really looking for evidence that often doesn't exist unless there's a lawsuit brought challenging something in the first place, because it's just not done routinely.
That's absolutely right. That it's often very difficult to get enough evidence to show that there is a link. And the higher the bar you draw for a plaintiff, obviously the more difficult it is for plaintiffs to recover. And your comment reminded me, my mentor Margaret Berger, who taught at Brooklyn Law School for many years, um, she she was famous for an article she published where she advocated for eliminating the general causation requirement entirely. That
Wow.
this is so difficult to prove, and really the harm here is not the general causation aspect. That the problem here is not that the drug caused the cancer. The problem here is that the company did not do enough testing, and she drew from ideas about informed consent and and other sort of failures to warn and those kinds of concerns to argue that, well, we could eliminate the general causation requirement and simply say, if you fail to warn about this particular hazard, then maybe you should be able to recover. Now, there are issues with that because you have to create enough of a link between the plaintiff and the defendant, but it does show that she was very concerned with the lack of funding for these kinds of studies, and then and ultimately, I think she was fed up with it and said, well, what if we envisioned a world where this was the way that we proceeded with lawsuits? The other thing that really strikes me too about, and this is specific to the glyphosate case, but I think this is true across the board. If you look at where these studies are done, it's kind of amazing that very few of them are done in the United States.
Yes.
So the glyphosate case, a lot of the studies are done in Sweden. And I think my reaction to that is, Sweden's a pretty small country. And why is it that Sweden keeps providing us with the information about the safety of products that are widely used in the United States? And I think it goes to the problem that you're identifying.
Yeah, I mean, I think that's a great point, and I think you could say that in this country we just allow companies a lot more freedom in terms of introducing products to the market. Those European countries, I think, are more top down, a lot more government regulation. A lot, their healthcare systems are very different. Academia is very different. And here we say, if you have a new chemical, go ahead, put it out in the market. If there's a problem that comes up later, we'll deal with it. Like you said, the tort system is designed for that, that if you are going to put a product into the stream of commerce out into the market and it's dangerous and it causes someone harm, we have a system for dealing with that in this country. Our legal system, our tort legal system says that that company can be held responsible, but you still have the problem of scientific evidence in the way. And that's why I think that it's remarkable what's happened in this Roundup case, because as somebody who's actually handled very complicated science cases, it's challenging. Often the science that is out there is science that has been controlled in one way or another, or influenced at least by the industry. And we haven't talked about that. That's for a whole other discussion. But, there are a lot of allegations in this Monsanto case that Monsanto was hiring ghostwriters to write scientific articles favorable to their side, to say that the health concerns are overblown. We've heard about that happening in the opioid cases too. The drug companies, paying doctors to go out on the lecture circuit and say that that oxycodone is fine and not something that is highly addictive. And so, guess what? Lots more people got hooked on these opioids. So, again, individuals don't really have the ability or the resources to control this science, and the government, a regulatory system, doesn't require it, and so it doesn't happen. But as you point out, and your mentor points out, we do have this requirement of causation. With the one bringing the claim against the company has the burden to show here that glyphosate did cause, and that's a big, often extremely expensive undertaking, and one that often doesn't happen even at all. Whether it's the Ford Pinto case from from a couple of generations ago on up to what happened in federal court in San Francisco just the other day in this Roundup case, it often doesn't happen at all unless there is some courtroom somewhere where these issues are put to the test, and that's what we have. That's what we've had happen here.
That's true. It will be. I am very curious to find out what happens in these cases. In many ways, they're reminiscent of many of the toxic torts that have come before.
Yeah.
And in many ways, I don't have a strong opinion as to which way the causation question cuts.
Yeah.
This could be the same as smoking, as you pointed out earlier, and just to concede an earlier point you made about governmental agencies, and governmental agencies can be quite slow. If you think about the history of smoking,
right,
studies showed as early as I think the 40s and 50s that smoking caused cancer, and there was really no governmental action on this for another several decades. Maybe I think it's 70s that the government started to move on it. So it could be that. It could be something like bendectin, where I think the general consensus is it does not cause birth defects, and the epidemiology ultimately came out and suggested that it didn't. But
just didn't
it could be either way, and you're sitting in this sort of uncertain zone where you don't know what to do with these cases.
It will be fascinating, and again, this case that's playing out right now in San Francisco, it's a multi-phase trial, but it's clearly going to have a big impact on thousands of other cases. One of the big mega chemical companies, Bayer, and given how the scientific issues play out in the courtroom, it could also have an impact on other toxic tort and exposure cases down the road. So fascinating story. Really hugely important set of issues. And by the way, a great conversation with Ed Chang. Ed, thank you very much. Professor of law at Vanderbilt University Law School and an expert in scientific evidence and evidence generally. And also, we'll just say again, host of the podcast, Excited Utterance. Check that out. Thank you so much for being on Good Law, Bad Law. I really appreciate it.
Well, thanks a lot. Thanks for having me, and I enjoyed our conversation.